Hello, friends. If you own your home outright and you are on Medicaid or approaching the age where you may need it, there is a legal program running in all 50 states right now that most seniors have never heard of. It is called the Medicaid Estate Recovery Program, and it means that after you die, the state can file a claim against your home to recover every dollar Medicaid spent on your care. Not a possibility, not a risk in certain circumstances, a legal requirement. Every state in America is required by federal law to attempt to recover Medicaid costs from your estate. And for most seniors, the home they paid off over 30 or 40 years is the only asset left to recover from. Today, I am going to walk you through exactly how this program works, who it affects, why a paid-off home is actually more vulnerable than most people realize, and the specific legal steps you can take right now to protect what you spent a lifetime building. Before we get into it, subscribe to this channel and turn on the bell. What I cover here are the financial and legal rules that affect seniors directly, the ones the system does not volunteer to explain. The people subscribed here find out in time to act. The ones who are not tend to find out when a letter arrives at their family's door after it is already too late. Subscribe, turn on notifications, and let us get into this. Here is the rule that most people do not know. Under federal law, specifically 42 U.S.C. Section 1396P, every state Medicaid program must seek reimbursement from the estate of a Medicaid recipient after they die. This applies to anyone who received Medicaid long-term care services, nursing home care, home and community-based services, related hospital and prescription drug services, and who was aged 55 or older when they received them. The state does not write to warn you this is coming. They do not ask your family in advance. After the Medicaid recipient dies, the state files a claim against the estate, and the estate, in most cases, is the house. Here is the part that catches families completely off guard. While you are alive and receiving Medicaid, your home is typically considered an exempt asset. It does not count against the Medicaid eligibility limits while you are living there. Families see this and reasonably conclude that the home is protected. It is not protected. The exemption while you are alive is not the same as protection after you die. The moment you pass away, the home stops being exempt and becomes the primary asset from which the state can recover its costs. Nursing home care averages roughly $119,000 per year in the United States. 2 years of Medicaid-funded nursing care generates a potential recovery claim of nearly $250,000 against your estate, against your home. Now, here is what makes this more urgent in 2026 than it was even a year ago. There are two things happening simultaneously. First, in January 2026, California reinstated strict asset limits for Medicaid long-term care eligibility. After years without an asset test, Medi-Cal is now actively enforcing eligibility limits again. That means more seniors in the most populous state in the country are now interacting with Medicaid rules they were previously unaware applied to them. Second, a bill called the Stop Unfair Medicaid Recoveries Act was introduced in Congress in January 2026. If passed, it would repeal the mandatory estate recovery requirement entirely. But as of today, it has not passed. Until it does, the recovery program is active and expanding. If you like what you are learning right now, please hit the like button. It takes 1 second, and it helps this information reach the families who need it most before it is too late. Here is the thing that most people get wrong when they first hear about estate recovery. They assume that because their home is jointly owned, or because they have named a beneficiary on their bank accounts, or because they have set up a simple will, the home is protected. In 27 states, it is not. Those 27 states use what is called expanded recovery, meaning the Medicaid recovery program can reach assets that do not go through probate, jointly held property, assets in revocable living trusts, and others. In the remaining 23 states and Washington, D.C., recovery is limited to probate assets only. In those states, certain planning strategies can move the home outside of probate's reach and effectively protect it from recovery. Now, let me tell you what actually works. The first protection strategy is a ladybird deed, also known as an enhanced life estate deed. Available in several states, including Michigan, Florida, Texas, Vermont, and West Virginia. A ladybird deed allows you to transfer your home to your children or heirs automatically at your death, while retaining full control of the property during your lifetime. Because the transfer happens outside of probate, in states with probate-only recovery, the home passes to your heirs without being available to Medicaid for recovery. In states that have it available, this is one of the most powerful and cost-effective tools for protecting the family home. The second strategy is an irrevocable Medicaid Asset Protection Trust. This is a trust you establish and transfer your home into at least 5 years before you need Medicaid, because of the 5-year look-back period. If you transfer your home to this type of trust and 5 years pass before you apply for Medicaid, the home is outside your countable assets and outside the reach of a state recovery. If you transfer it and apply for Medicaid within 5 years, the transfer creates a penalty period of ineligibility. The timing is critical. This strategy requires advanced planning. But for families where the senior is currently healthy and the 5-year window is available, it is one of the strongest protections that exists. The third thing every family must know is the undue hardship waiver. Every state is required by federal law to have a process for waiving a state recovery when recovery would cause undue hardship. This waiver is available to families after the Medicaid recipient has died, if pursuing recovery would, for example, result in heirs losing their primary residence or their primary source of income. The state will not proactively offer this waiver. The family must apply for it. And in many cases, families who would have qualified for a waiver never receive one simply because no one told them it existed. Drop a comment right now. Type home if you or someone in your family owns a paid-off home and receives Medicaid or might need it in the future. It takes 2 seconds, and it helps me understand exactly who is watching this video. Here is what you need to do right now. First, find out which category your state falls into. Is it a probate-only state or an expanded recovery state? Your state Medicaid agency's website has this information. A certified elder law attorney in your state can also tell you immediately and explain what strategies are available to you specifically. Second, if you are currently healthy and the 5-year window is available, explore the irrevocable Medicaid Asset Protection Trust with a qualified elder law attorney before the planning window closes. Third, if you live in a ladybird deed state, ask a certified elder law attorney whether this option can protect your home now. Fourth, if a Medicaid recipient in your family has already passed and a recovery claim has arrived, do not simply accept it. Ask the state Medicaid agency about the undue hardship waiver before signing anything. To find a certified elder law attorney in your state, go to NALA.org, the National Academy of Elder Law Attorneys. Initial consultations are often free, and acting early multiplies your options significantly. So here is the summary. The Medicaid Estate Recovery Program is active in all 50 states. Every state is required by federal law to attempt to recover Medicaid long-term care costs from a deceased recipient's estate. While your home is exempt from Medicaid eligibility rules while you are alive, it is not protected from a state recovery after you die. Nursing home care averages $119,000 per year. 2 years of care can generate a recovery claim of nearly $250,000 against your estate. 27 states use expanded recovery, reaching beyond probate. 23 states and D.C. limit recovery to probate assets only, where planning strategies like ladybird deeds can protect the home. An irrevocable Medicaid Asset Protection Trust established at least 5 years before you need Medicaid can remove your home from the recovery reach entirely. The undue hardship waiver is available in every state, but the family must apply. It is never offered automatically. The Stop Unfair Medicaid Recoveries Act was introduced in January 2026, but has not yet passed. Until it does, this program is active. Find a certified elder law attorney at NALA.org. Act now while the planning window is still open. Subscribe, and please share this with any family member who owns a home and is on Medicaid or approaching the age where they may need it. Most families find out about estate recovery after it is already too late to plan around it. You can change that for someone you love.